Second Chance Amendment Act finally went into effect in March of 2025. Well, at least parts of it went into effect. And in this video, I'll explain the DC Second Chance Amendment Act of 2022, which despite its name did not take effect until March 2025. I'll explain while this is a great piece of legislation for anyone who favors criminal justice reform, the law also has a huge blind spot in the legislation that will negatively affect thousands of individuals eligible for sealing under the law. My name is Joseph Scrofano, and I'm the founder of Scrofano Law PC, where we represent individuals under investigation or charged with the crime in the District of Columbia, Maryland, and Northern Virginia. We typically handle anywhere between 30 to 60 motions to seal or expungements in DC. And so this change is big news for us and to anyone who has ever been arrested in the District of Columbia. Overall, this new law is a huge improvement to the status quo, although certain provisions of the law are still not in effect, and the law created some unforeseen consequences for individuals who will not get their records sealed or expunged for another year or two. It does make it easier to seal or expunge criminal records, giving thousands of people in the district a real shot at a fresh start, and removes some of the complicated and cumbersome requirements of the old criminal record sealing law. So, what exactly does the law do? The Second Chance Amendment Act updates and expands DC's record sealing and expungement laws for criminal records in simple terms. It makes it easier to wipe the slate clean. Before this law, getting a record sealed in DC was overly complicated and had burdensome eligibility requirements. Previously posted a video on how to get your record sealed under the old law here, and we've also posted a video about the Youth Rehabilitation Act, which prior to this law was the only way to get a felony off your record in DC, and it applied only to individuals under 25 at the time of the offense. This law does not change the Youth Rehabilitation Act, or YRA, which deals with set-asides of convictions rather than sealing records. Now, for the first time, certain felony convictions are eligible for sealing under the new law, regardless of what age you were at the time of the offense. Now, it's important to understand some of the old provisions, and I'll explain what changes were made. Prior to the Second Chance Amendment Act, there were a couple different ways to seal your record. If you were arrested but not convicted and can prove by a preponderance of the evidence that either the crime didn't occur or someone else committed the crime, you could file a motion to seal based on actual innocence. If your charge was subsequently legalized or decriminalized, like an old simple possession of marijuana case, you could file a motion to seal based on a subsequent legalized or decriminalized offense. In those motions, the burden was on the government or the prosecutor to demonstrate that the offense was not subsequently legalized or decriminalized. Aside from those special circumstances, the old criminal record sealing law basically created three categories of records that could be sealed with waiting periods and cumbersome eligibility requirements. These categories included dismissed eligible misdemeanor non-convictions, dismissed ineligible misdemeanor non-convictions, and eligible conviction. Dismissed eligible misdemeanor non-convictions included charges like unlawful entry, non-domestic violence, simple assault, and simple drug possession. For these charges, the waiting period was 2 years from the date of dismissal. Now, with dismissed ineligible misdemeanors included a list of more serious misdemeanor offenses like DWI or DUI, OWI, and any domestic violence misdemeanor. This also included things like misdemeanor sex assault. For those charged but not convicted, the waiting period was 4 years from the date of dismissal or 3 years from the date the case was no papered. No papered means the prosecutor declined to file charges after the arrest. Lastly, the only convictions eligible for sealing under the old law included the same list of eligible misdemeanors and required a waiting period of 8 years from the completion of the sentence. Notably, all ineligible misdemeanor convictions, again, cases like DUI and domestic violence offenses, could never be sealed under the old law. In addition, felony convictions other than Bail Reform Act violations were all ineligible for sealing basically forever. That meant if you were convicted of a DUI, a domestic violence offense, or a felony offense, there was basically no legal avenue to get your conviction sealed. Now, for far too long. Many people in our community have been held back by past mistakes, some of which shouldn't even be on the records in the first place. Now, how does the Second Chance Amendment Act improve the situation? Well, first, the law creates a process for both automatic expungements and automatic sealings. For automatic expungements, if you were charged or convicted of a crime that's since been decriminalized or legalized, like simple possession of marijuana before 2015, your record will be wiped clean automatically without you having to file a motion. For the formally eligible misdemeanor non-convictions mentioned before, like non-domestic violence, simple assault, unlawful entry, simple drug possession, the law has created a process for automatically sealing those records after the case is dismissed. Unfortunately, however, the City Council screwed up on this provision, and the automatic sealing and expungements will not take effect until April of 2026, and the court will have until October of 2027 to complete the process of sealing and expunging old eligible records. It's also unclear whether the court will be required to notify individuals that their record has been sealed or expunged, so you may not even know if your case gets sealed. The main screw up here, though, is that these cases were formally eligible to be sealed or expunged by filing a motion prior to March of 2025 when the new law went into effect, but there is no provision in the law for individuals in this category to ask the court to seal or expunge sooner by filing a motion. That means the only thing you can do if you have an old dismissed misdemeanor like unlawful entry or simple assault that's not domestic violence, the only thing you can do is wait. Automatic sealing applies for former eligible misdemeanor convictions after a 10-year waiting period as well. But as I'll explain, the law does not prohibit you from filing sooner for an eligible misdemeanor conviction, unlike eligible misdemeanor dismissal. On the other hand, the law does allow for filing a motion to seal your records if you have a formally ineligible dismissed misdemeanor like DUI or domestic violence offense. The biggest improvement here is there is no longer any waiting period to move to seal one of these more serious misdemeanor dismissals. That means you can file the day after your case is dismissed. Now, it's not guaranteed that the court will grant the motion, but you are eligible to file the motion the moment the charge is dismissed. You still have to show, though, by a preponderance of evidence that it's in the interest of justice to seal the record. In addition, the new law no longer distinguishes between ineligible and eligible when it comes to filing motions for misdemeanor convictions for sealing. Any misdemeanor conviction, be it a DUI, a domestic violence offense, or any less serious misdemeanor like unlawful entry or simple drug possession, they can all be eligible for sealing 5 years from the completion of the sentence. Finally, and arguably the most impactful change to the law, is felony convictions that are not in the master grid 1, 2, or 3 of the District of Columbia sentencing guidelines are eligible for sealing 8 years from the completion of the sentence. The excluded felony convictions include very serious offenses like first and second degree murder, first degree sexual abuse, voluntary manslaughter while armed, and first degree child sex abuse. It also includes felonies like carjacking, assault with the intent to kill, and first degree burglary, if the while armed enhancement is applied to the sentence. So, what offenses can be sealed by motion? Formally ineligible misdemeanor dismissals, all misdemeanor convictions 5 years after the completion of the sentence, and non-master grid 1, 2, or 3 felony convictions. Fugitive matters also remain eligible for sealing under the new law. Fugitive matter is when DC arrests you for having a warrant in another jurisdiction and they extradite you. In all instances of sealing by motion, the burden is on the movant to show by a preponderance of the evidence that it's in the interest of public justice to seal the record. Again, noticeably absent from this list are formally dismissed eligible less serious misdemeanors, like unlawful entry. So, to recap, you have an old less serious misdemeanor dismissal for something like non-domestic violence, simple assault, unlawful entry, or simple drug possession. You can't file a motion to seal your record. Unless the City Council fixes the gap in this legislation, your only option is to wait for automatic sealing to go into effect in 2026 and 2027. You also have the option of moving for an actual innocence expungement, which largely remains the same in the new law. But again, keep in mind you must be actual innocent of the charge and be able to submit evidence proving that. If you have a more serious dismissed misdemeanor, like a DUI or domestic violence misdemeanor charge, you can file by motion for sealing immediately. This is a big change from the old law, which required a 3 to 4 year waiting period. If you have any misdemeanor conviction, you can file by motion as long as 5 years have elapsed since you completed your sentence, which includes any period of probation. Finally, if you have a felony conviction that is not in Master Group 1, 2, or 3 of the DC sentencing guidelines, you can file by motion as long as 8 years have elapsed since the conclusion of your sentence. Again, that sentence includes any period of probation. So, assuming you fall into one of the categories where you can file a motion rather than wait for automatic sealing, how do you show by a preponderance of the evidence that it's in the interest of justice to seal your record? Well, one obvious way is to hire an experienced DC expungement lawyer who can draft and file the motion for you. The court will weigh factors like your interest in getting the record sealed, the community's interest in advancing your rehabilitation and reintegration by sealing the records, and they'll weigh that against the community's interest in having access to the record. The court can also consider additional factors like the nature of the offense, your character, the time that has elapsed since the arrest, your employment history, your criminal history, any efforts of rehabilitation, and whether the government opposes or does not oppose the motion, among other things. Considering these factors, you want to be able to show all the positive things you've done with your life since being arrested or convicted. But you also need to show how the arrest or conviction has negatively impacted you. This could involve jobs or promotions you've missed due to your record, trouble getting housing, or even just the shame and embarrassment of knowing that the criminal records are out there available to the public. You should also know that if the judge denies the motion, that's not the end. The law allows you to refile the motion if you're denied no sooner than 1 year after the denial. And if the judge denies a second motion, you still have one more bite at the apple and can file a third and final motion at least 1 year after the second denial. The criminal justice system has been stacked against people for far too long. This law is a positive step in the right direction, but it's not automatic for everyone, and it's left a crucial gap for otherwise eligible individuals. If you think you qualify for an expungement or sealing, don't wait. You need to take action, and we can help. Keep in mind, even if you are eligible and successful, the process can take at least 6 months to work its way through the system. Don't wait until you get that dream job offer subject to a background check to start the process. The key takeaway here is that the law is finally catching up with reality. People deserve a chance to rebuild their lives without a criminal record hanging over their head. If you have a DC criminal record, feel free to comment below and I'll reply on how the new law may apply to your situation. If you or someone you know is ready to take advantage of the Second Chance Amendment Act, call us today. Or if you just like this video and are interested in criminal law issues, please consider giving it a thumbs up and subscribing to our channel to learn more about legal topics and issues involving criminal law in the District of Columbia, Maryland, and Virginia.